Thank you very much. I'm looking forward to this conversation. I want to thank Molly Bartlett from the Shriver Center for pulling me out of my area of expertise and plopping me into a new one that has been kind of fun getting caught up on. And I'll, in a moment, sort of share with you most of what I've learned was just as a quick over of the Affordable Care Act. Briefly, the Act has three fundamental goals. It's to decrease the cost of health care in the United States, to improve the quality of health care in the United States, to make health care more accessible in the United States, particularly to the uninsured. A fundamental provision of the Act is to require virtually every person in the United States to have health insurance beginning in 2014. The law was enacted in March 2010. Numerous lawsuits were filed almost immediately, and many of those were dismissed. In the end, 7 appellate courts handed down decisions, and the decisions were a mixed bag. Last November, the United States Supreme Court agreed to take on certain appeals, and it will hear oral arguments at the end of next month on 4 issues, and a decision is expected in June. Our speakers today will talk about 2 of the issues in particular: the requirement that individuals purchase health insurance or face a financial penalty, and the expansion of eligibility for Medicaid. Sheldon Neymaud and John Bowman are eminently qualified to speak on these issues, and I could speak at length about their qualifications, but I'll share just a few so that we can move quickly into their remarks and discussion. Sheldon Neymaud is a professor at the Chicago-Kent College of Law and co-director of its Institute for Law and the Humanities. He is an expert on constitutional law and has argued civil rights cases in the United States Supreme Court and many other federal courts. Professor Neymaud has served as chair of the section on civil rights, the section on law and education, and the section on law and religion of the Association of American Law Schools. John Bowman is the president and advocacy director of the Shriver Center. He is an expert on Medicaid and spearheaded the statewide efforts in Illinois to create both the Family Care Program, which provides health care insurance for up to 400,000 working poor parents of minor children, and All Kids, the first state plan to extend health coverage to every child. He is currently focusing on state implementation of federal health care reform. Sheldon, we first met, and I guess I can call him Sheldon, will give us a little bit of an overview of the Act,
Sure.
and then we'll start a conversation which we want to include you. If you have a comment, you have a question, raise your hand, and we'll wing it, okay? And we'll go until 9:45.
Good morning, and thanks for being here. I'm delighted to have been invited to participate. Since I teach constitutional law, this is supposedly right up my alley, but you will all be the judges of that as we go along. This is a very high-profile federal statute. It's the Patient Protection and Affordable Care Act, as was just discussed or mentioned, and it is over 900 pages long. Pretty complex indeed. And let me just very quickly, to start off, read you a short paragraph from the 11th Circuit decision that is currently pending in the United States Supreme Court that describes the statute. This opinion, by the way, is itself 90 pages long, and there's a dissent of about 40 or 45 pages. So there's a lot of action here. To reduce the number of the uninsured, the Act employs 5 main tools: comprehensive insurance industry reforms, which alter private insurers' underwriting practices, guarantee issuance of coverage, overhaul their health insurance benefit products, and restrict their premium pricing structure. 2, creation of state-run health benefit exchanges as new marketplaces. 3, a mandate that individuals must purchase and continuously maintain health insurance or pay annual penalties. 4, penalties on private employers who do not offer at least some type of health plan to their employees. And 5, the expansion of Medicaid eligibility and subsidies. Now, as I looked at this opinion and thought about it, I got the impression that there were 2 major purposes of this act. The first is that we've got about 50 million uninsured persons in this country, people without health care insurance. Virtually all of them at some point go to a hospital, go to a doctor. They cannot pay. Therefore, the costs of their health care services are being borne by the health care providers. Those costs are then shifted over to the insurance companies, and the insurance companies then shift the costs ultimately to us. So in effect, all of us who are paying for health care insurance are subsidizing many of the people who do not have health care insurance. That's one major issue, the attempt to reduce costs in this setting for everybody. The second issue is the number of uninsured persons. It's 50 million. Approximately 10 or 12 million of them are unable to get insurance because of pre-existing conditions. So a second major purpose of this act is to do something about them. One of the most challenged or controversial, one of the more controversial aspects of this act is the individual mandate, which in fact requires every one of us, there are some exceptions, but virtually everybody, to buy insurance, health care insurance, or otherwise pay a penalty, a so-called penalty. That's an interesting issue in and of itself that we will talk about. And interestingly enough, and this becomes relevant later as we'll see, interesting enough, that penalty, so-called penalty, is provided for when you pay your income taxes on April 15th. And the way it's enforced is it's through as an offset to any taxes you might pay. There is otherwise no enforceable mechanism so far as I know. No other criminal sanctions, no civil sanctions. It's an offset to taxes. Now let's talk about the individual mandate. And in order to do that intelligently, we need to talk about the Constitution. As Tocqueville said almost a couple of hundred years ago, every major social issue ultimately comes to the United States Supreme Court. So here we go again. Congress, and here's a 30-second primer on the Constitution. Congress cannot act unless it acts through an enumerated power. It's as simple and as complicated as that. The question, therefore, is whether Congress has the power under either the Commerce Clause, which is what we'll spend most of our time on, or the taxing power to enact this individual mandate. What is the Commerce power? Well, Article 1, Section 8, Clause 3 is the Commerce Clause. And what it does is give power to Congress to regulate what we might call interstate commerce. It's commerce among the several states. There is no question whatever that Congress has power to regulate interstate commerce. It can regulate roads. It can regulate automobile traffic. It can regulate railroad traffic. That is not the issue at all in most difficult Commerce Clause cases. The issue is the extent to which Congress can regulate local or seemingly local or intra-state activities. And here is where this entire debate runs right up against my favorite F word. Don't get shocked. It's federalism. Federalism is part of our constitutional structure, which is vertical in the same way that separation of powers and checks and balances that you've all heard about as educated citizens is horizontal. And federalism has many purposes, one of which is to promote experimentation among the states, but another, which is not spoken about very much, is actually to have the states serve as buffers between us and a possibly, I kid you not, possibly tyrannical national government. okay, as buffers. So many people believe that federalism structure is as important for preventing tyranny by the national government as separation of powers is. So the struggle from day one with the Commerce Clause has been, how do we take account of the broad scope of congressional power under the Commerce Clause on the one hand, and the concern with federalism, with the federalism structure on the other. For many years, late 19th century and early 20th century, it was the Supreme Court of the United States that was enforcing federalism. The Supreme Court was intervening in many cases involving the scope of congressional power, and some cases upholding such attempts to regulate commerce intrastate, and in other cases striking these efforts down. And those of you with a good sense of history, and that probably includes everybody here, will remember that in the 1930s, the United States Supreme Court struck down under the guise of congressional exceeding of its commerce power a whole bunch of New Deal legislation. That changed in 1936 and 1937 when the justices shifted, the switch in time that saved 9, and the Supreme Court, beginning in the 1930s, middle 1930s, began to defer more and more to congressional exercises of the commerce power over local matters. So much so that in this landmark decision, I think it was 1942, Wickard versus Filburn, the Supreme Court held that, in fact, Congress had the authority to regulate the amount of wheat one little farmer can grow for his own consumption. The argument being that it wasn't just this farmer and his production of wheat that was affecting interstate commerce. You aggregate all of the farmers together, and you see that this has a substantial effect on interstate commerce. And that shows you how far the Supreme Court was willing to defer to Congress in its exercise of the commerce power. The justices had changed at that point. We were going through a recession. We were about to go into, we were in the Second World War already in 1942. You get the idea. That's the way it was until 1995, when one aspect of the Rehnquist Revolution began, the federalism revolution. And in 1995, the Supreme Court struck down in the Lopez case a federal statute that attempted to regulate the possession of guns near schools. Within 1,000 feet of a school, you could not have a gun, otherwise you were subject to federal criminal sanctions. And the Supreme Court gave us a test, we may get into it later, which seemed to limit the scope of the commerce power. This was after 60 years, you understand. Middle 30s till middle 90s, and a threshold consideration of those cases, in the cases from 95 on. There was also the Morrison case, the Violence Against Women Act case. The threshold consideration is whether Congress was regulating a local activity that was economic or commercial in nature. And that will bring us in a little bit, once John gets his chance to talk and we have this thing opened up, to the question of whether the decision whether to buy insurance, health care insurance, is first of all an economic activity, and secondly, whether it is so different from everything else the Supreme Court has upheld that we need to say, hey, wait just a minute here, because if Congress can do that, what can Congress not force us to buy? And I'll have more to say about this later, as well as the taxing power issue, which is Article 1, Section 8, Clause 1. But enough for now.
Okay, well, why don't we switch to John and lay the landscape for the other issue, and then we'll start the discussion.
Okay, so what we decided to, is this on?
Yeah.
What we decided to focus on today were the two substantive issues at stake in the Supreme Court, two of the four issues that are there. And I'll touch on the other two issues, but we want to concentrate on the two substantive issues. So the four issues are the commerce power regarding the individual mandate, and secondly, and I'll go into more detail in a second, whether the Medicaid expansion that's in the Affordable Care Act was a violation of Congress's power under the spending clause of the Constitution. The other two arguments are, if you strike down the individual mandate because it exceeds the commerce power, is it severable from the rest of the Act? Do you have to also throw out the whole rest of the Act, no matter if it relates to the Commerce Clause individual mandate or not? And just to tell you what the battleground is there, the federal government, in defending the Act, says actually it's not severable from the provisions of the Act that have to do with the guaranteed issuance of insurance regardless of pre-existing conditions, and the community rating, which is that you can't discriminate in pricing of insurance based on a pre-existing condition. And so the reason for that is that the individual mandate is the strategy by which Congress wanted healthy people to be in the insurance pool. And if healthy people are in the insurance pool paying premiums, then the insurance industry can afford to cover everybody with pre-existing conditions and not discriminate against them. But if you take away the individual mandate, you might not have all the healthy people participating, and it sort of upsets the strategy. So that's what the federal government said. Now, the court that ruled on it, saying it is severable, the 11th Circuit, reversing the lower court, which had said, struck down the whole act in Florida. The 11th Circuit said it's severable from everything. So there's actually an interesting counterpoint on that issue. The other issue that's before the court is something called the Anti-Injunction Act. The Anti-Injunction Act is a provision of the Internal Revenue Code that says you can't get an injunction against paying a tax. You have to, if you dispute whether you owe taxes, you have to either pay it and then appeal and try and get your money back, or you have to not pay it and get prosecuted for it and raise it as a defense to the prosecution. But you can't clog up the courts with injunctions saying you shouldn't have to pay taxes. So that's the Injunction Act, and if the individual mandate is a tax, then the lawsuits are premature. Nobody has to pay that until 2015. And so the Fourth Circuit actually threw out this claim based on the Anti-Injunction Act. And so that'll be before the court as well. If it's a penalty, the act doesn't apply. If it's a tax, the act applies. And that's not dictionary definitions. Those are highly technical definitions, and they depend on where it's placed in the code and all that kind of stuff. But that's the issue that'll be before the court. They've scheduled 3 days of arguments in March, I think 26th, 7th, and 8th. A whole day on the individual mandate, I think a whole day on the Anti-Injunction Act, and then the third day is divided between severability and this Medicaid issue that I'm about to describe. So I'm going to go into a little detail on this claim about the Medicaid issue because it's a little complex, and just to set up the conversation. So Medicaid is what's called cooperative federalism. The federal government said in 1965, part of Lyndon Johnson's legislation, we think it's a good idea for low-income people, or at least some of them, to be covered by health coverage under this new Medicaid program. States, you don't have to participate, but if you do, we will offer you between 50 and 83% of the costs of it as a federal share of the cost. But the money comes with strings attached, and you have to abide by the federal conditions for getting that money. Some of those conditions involved who was eligible, and some of them involved what the minimum types of coverage you have to offer. But the states had wide latitude with how much they paid to doctors and hospitals and others. A lot of coverages are optional. The states had a lot of flexibility, but there was a bottom line of federal requirements. Also in that initial offer of funding was the provision that said, and mind you, we reserve the right to change or repeal or add to the restrictions on the funding. So up front, we're telling you that. So if you take this deal, you take that with it. And so eventually, every state took the deal. Since probably 1980 or so, every state participates. And in fact, the eligibility rules have changed repeatedly. The mandated covered populations have been added to over and over again. None of those have been struck down as federal overreaching. And what the Affordable Care Act would do, what Medicaid covers is you get health insurance if you're poor and if you are a certain type of person. It's called categories. So you have to be a child, a parent, a disabled person, or age 65 or above. Right? That leaves a great number of people, most of you younger folks in the room, for example, able-bodied, non-parenting, non-elderly folks are not there, no matter how poor you are. So what the Affordable Care Act does is to eliminate the categories and say everybody with income under 138% of the poverty level, about $11,000 a year, is eligible. It's a big expansion. It would reach about 16 million people. In Illinois, 700,000 or 800,000. And so the challenge to that, also part of the deal in the Affordable Care Act is that that expansion is 100% federally funded for the first 3 years, and then over another 3 years it gradually decreases until it settles in at 90% federal funding on into the future. So it's a pretty good deal. What the plaintiffs are saying, 26 different states, virtually the morning after the act was signed into law, 26, well, actually initially 12 states with particularly aggressive attorneys general filed this case in Florida. Eventually 26 joined. There are now about 6 states on the other side of it. Filed this case, and they say it's based on the spending clause of Article 1 of the Constitution. Article 1, Section 8 says, Congress shall have power to pay the debts and provide for the common defense and general welfare of the United States. Pretty simple. Further, it's been determined that Congress has the power to fix the terms of how it gives money to the states. So Congress can say, here's some money, but only if X, okay? There are 4 recognized restrictions on this power. 1, it has to be in pursuit of the general welfare, according to the words of the clause. 2, conditions on the funds must be reasonably related to the legislation's goal. 3, the conditions have to be unambiguous at the outset so that the states know what they're getting into. And 4, it must not require the states to do something unconstitutional in order to get the money. The plaintiffs in the case don't allege that any of those limitations are involved here. They agree that this particular grant of federal funds with restrictions doesn't violate any of that. Instead, they claim that there's a 5th restriction, and that's anchored in the 10th Amendment's reservation of powers to the state. The 10th Amendment says whatever the Constitution doesn't expressly give to the federal government to do or to have power over is expressly reserved to the states. The 10th Amendment is the flagship of the political forces in the country that want to limit the size of the federal government. And it says you must not impose restrictions on funding that coerce the state into compliance with the federal objective. That is, if you do it in such a way that the states have no choice in the matter, it's coercive and exceeds the authority under the spending clause as limited by the 10th Amendment. Now, this is something that is not a restriction on the spending clause that's been adopted by the Supreme Court, but it's been talked about twice by the Supreme Court, which we lawyers call dicta. It wasn't part of any decision, but it was a conversation in Supreme Court opinions. One of them in 1937, in a New Deal legislation involving the then new unemployment insurance program, a company, Stewart Machine Company, sued to resist having to pay the unemployment insurance tax, saying the state had been coerced into doing it because the federal government offered them inducements. And the court said, well, maybe there's a doctrine like that, perhaps, but if there is one, it's not violated here. The state had a choice. And then 50 years later, again, it heated up again in 87, a case called South Dakota versus Dole. The state attacked a federal restriction on highway funds that said you lose 5% of those funds unless you enact a 21-year-old drinking rule. And the court again said, well, we've talked about this coercion doctrine, and if there is one, it doesn't apply here. So the court has never laid out a test. It's slippery waters. I mean, once you get into it, it's very hard to see where that line is drawn. The court's never used it, and no circuit court has ever used it, and has never laid out a test. And because of that, 6 of the circuits who've been asked to apply a coercion doctrine have said there's no such thing. There's no limit on the spending power to restrict the grant of federal funds to the states. And some other circuits, including now the 11th Circuit, have said, yes, we think there is a coercion doctrine. We don't quite sure what it is. Nobody's ever done it, but there is one. And the 11th Circuit announced its version of a coercion doctrine, and it said, and here's what it says. Congress cannot place restrictions so burdensome and threaten the loss of funds so great and important to the state's integral function as a state, funds that the state has come to rely on heavily as part of its everyday service to its citizens, as to compel the state to participate in the, quote, optional legislation. This is the point where pressure turns into compulsion. That's what the 11th Circuit says is the coercion doctrine that limits the federal spending power. However, it said it doesn't apply here. So it ruled in favor of the Affordable Care Act's Medicaid expansion, saying 5 things, and then I'll be done. 1, the state knew from day one that the feds could change the conditions, and they have done so repeatedly, and none of them have been struck down as coercive. 2, the feds will bear almost all the cost. In that context, coercion is more rhetoric than reality, quote unquote. 3, states have 4 years to decide, it doesn't take effect till 2014, and to plan alternatives for covering their citizens if they don't want to participate in Medicaid. 4, the states have the power to tax and raise revenue, so they do have options. You may not like them, but they have options. And 5, the Medicaid Act does not automatically withdraw all Medicaid funding if you refuse to do the expansion. The federal government has options to withdraw just part of the Medicaid funding. So it isn't an automatic do the expansion, or you not only lose funding for that, you lose all your Medicaid funding. So that's what sets it up in the Supreme Court, is the states, the challenging states, the plaintiffs that have challenged that ruling by the 11th Circuit. In their brief, we've seen their brief, we haven't seen the respondent's brief. They spend about half of it on this argument to establish a coercion exception to the spending power, that there must be such a rule. So in essence, defending that part of the 11th Circuit's ruling. And this is the big sort of ideological battle in the case to break through on this longstanding constitutional argument about what the people who are in favor of aggressive federalism call and capitalize our federalism, capital O, capital F. And that's how it's phrased in the brief. And then going on to say, and it has to apply here. If it can't apply to this, what can it apply to? If there's a rule at all, it has to cover this. You know, if there's a fuzzy line somewhere, this one is well within it. And which is typical briefing rhetoric. But that's the argument that's set up for the court. There's profound consequences for the struggle between state authority and federal authority, certainly between Medicaid and the attempt to cover people. If this is struck down, it's a very serious blow. And the whole Medicaid structure, which is so important, actually not just for health care, but for state budgets around the country, which is actually an argument that it's very difficult for them to turn down this deal. And highway funding, education funding, all kinds of different programs that are based on the spending clause would be opened up to litigation around this, what is and isn't coercion, in the terms of the federal offer of funds. So I'll stop there.
John talked about potential consequences. Could you do that a little bit as well for the individual mandate?
Well, the 11th Circuit did strike down the individual mandate. And in terms of its reasoning in particular, it actually said that it didn't matter whether the failure to buy health care insurance was an economic activity or not, which I found interesting, because it said even if it's an economic activity, there would be no limits to the congressional power under the Commerce Clause if it were to uphold the individual mandate. And as I read this very lengthy opinion, that was really the crux of the 11th Circuit's decision. It could find no real limits. And here's what I think is really implicated here. I would call it constitutional trust. I would characterize it as this question, as involving this question. Whom do you trust to enforce federalism constraints? Do you trust the United States Supreme Court to do it? Or do you, which is not a politically accountable body, or do you trust Congress to enforce federalism? And let me just give you an example of that. This is not just an ivory tower question. Congress has power clearly under the taxing power. Do we trust Congress not to tax us at a 99% tax rate? The answer is, I hope, of course we do, because nobody would win re-election under those circumstances. I mean, that's really one of the underlying theories of our Constitution, our democracy, the notion of political accountability. So when the 11th Circuit said there would be no limits here if we were to uphold the individual mandate, it was really just kicking the ball to the United States Supreme Court in this really high visibility case. It didn't feel comfortable upholding the individual mandate, and it wanted to set up a test case in the United States Supreme Court. The dissent, Judge Marcus in the 11th Circuit, said something intriguing. And I may be putting some words into his mouth, but I happen to agree with him. I think, and he seems to say, that the individual mandate is an easy Commerce Clause case. I think it's easy. I think Judge Marcus thinks it is easy too. I thought it was easy before I read his opinion, after all these years of teaching. I think the failure to buy, the refusal to buy insurance, healthcare insurance, is clearly an economic activity. I think given the extent of governmental regulation of healthcare services and healthcare insurance, it is both, healthcare insurance is regulated both by states and by the federal government. You put all these individual decisions not to buy together, and you have a substantial economic effect. Where do you draw the line? Well, let's make one thing very clear. Can government, if the individual mandate is upheld, force us to exercise? God forbid. That should be required. Can it force us to eat healthy? Okay? I think the short answer is no. That's really not a Commerce Clause question. That's really what we would call a substantive due process question. It has to do with personal decisions as to how we live our own lives. And I don't think that's Commerce Clause. I think we would probably have a substantive due process right to resist that, a Fifth Amendment substantive due process right. What about other possible required purchases? Could government require us to purchase an automobile, for example, to help out? Well, in theory, I suppose, under my approach to the individual mandate. But in practice, it's not going to happen. And since when, just to continue this rhetorical trope of mine, since when do we trust a politically unaccountable body to make these kinds of eminently political decisions rather than the politically accountable body? So I think that's what's at the heart of all this. And while I'm at it, and let me just make this last point, most of you probably know this already, but I'm going to say it anyway, and that is we hope that when courts decide issues of constitutionality, they are not deciding whether the legislation that's being challenged is good or bad, whether it's wise or not wise. We hope they are not injecting their own personal views of wisdom or lack thereof. We hope what they are doing is their best, it's not perfect, is their best to decide whether this is indeed constitutional based upon tenable interpretations of the commerce power in particular and the constitutional structure as a whole. Is this a hot political issue? You betcha it's a hot political issue. But the 11th Circuit's argument about there would be no limits, that one doesn't persuade me at all. I think this is an easy Commerce Clause case. But then again, if you're going to ask me how I would predict, what I would predict about the outcome, I thought when Bush v. Gore was coming down, I thought there was, and I said this, no way the Supreme Court is going to get involved in selecting the President of the United States. So I guess my thoughts may be worth what you're paying for them. And this is a free breakfast, isn't it?
That's a great transition. And the question I'd love to ask, of course, is what do you think is going to happen, which I suspect neither of you will say. But let me try to, finesse that a bit. And can you talk about what you've heard from this current court that fits into these arguments to give us some sense of where their heads may be?
Well, yeah, that's always tricky waters. Let me just add a footnote to Sheldon's remarks. Sure. Is that the Sixth and the D.C. circuits have upheld the individual mandate, taking what was to them the easy out, and there's a conflict in the circuit, which is why it's in the Supreme Court. And well, I think, and I saw this. I don't claim this for myself. I saw it in a blog somewhere. There's some reason to suspect that Roberts might join the so-called liberal judges and perhaps Kennedy in a 6-3 lineup, and with Roberts joining that majority in order to write the opinion and to do, to write it narrowly, or perhaps to establish a coercion exception to the spending clause power, or otherwise write a narrow decision about the Commerce Clause. That's one possible outcome if for those of us who are favorable to the ACA and feel like being optimists. So that's one possibility.
I would add the following to this. In addition to the commerce power that we've been talking about, and we may or may not get to the taxing power, but there's also something that goes all the way back for the lawyers and law students among the audience. Good old Chief Justice Marshall in McCulloch v. Maryland. The necessary and proper clause. And I mention this now because the 11th Circuit talks about it and basically rejects a necessary and proper clause approach. But here is the argument, and I'll tell you who buys into this, who may buy into it here as well. The argument is if Congress enacts legislation under the Commerce Clause, which has an end that is legitimate under the Commerce Clause, then it can enact whatever means it considers to be reasonably appropriate to promoting that end. Now think about this. What we're trying to do is, what Congress is trying to do is reduce medical insurance, medical care costs around the country. And that clearly has interstate implications, interstate aspects. How do we do that? Well, one way to do that is to enact an individual mandate, whether you call it economic activity or not. That could be characterized as necessary and proper in order to promote the legitimate end of regulating interstate commerce in health care. And the one who made that argument in the Raich case, which was some years ago involving medical marijuana, where the Supreme Court held that indeed Congress could prohibit homegrown marijuana for purely medical use. Congress could prohibit that, even though it was pretty much of a local activity. It was Justice Scalia who wrote a concurring opinion in that case. So he may be possibly added on to your 6-3 here. It remains to be seen. Now, that was a drug case, and one can argue that drugs are incredibly heavily regulated by Congress, Controlled Substances Act and the like, and these are dangerous and therefore part of a comprehensive regulatory scheme, which might not be the same as our regulatory scheme here. I think that would be a distinction without a difference, but you never know what's going to happen. If you want me to go on a limb and a prediction, I think the Supreme Court is going to uphold the individual mandate. It certainly should, in my view, but I think it's going to, but we shall see. You remember my Bush v. Gore prediction, too.
Yeah, briefly, if it is not upheld, what's the practical impact for the
Well, it's
country?
what John was talking about earlier in terms of severability. Can the individual mandate be severed from the rest of the Act? And without going into too much detail, when Congress says, yes, it's severable, we sever. When Congress says, no, it's not severable, we don't sever. In its inimitable wisdom here, what did Congress say? Nothing about that. So therefore, you ask, what would Congress have intended? There is a presumption of severability, and I think in this case that presumption is probably going to carry the day. Indeed, the 11th Circuit in this regard did a halfway decent job of showing that indeed the statute as a whole can stand even if the individual mandate is struck down, as the 11th Circuit did.
But it stands, what's left with it then, if you don't have that measure? I mean, the rest of the statute stands, but do we get anywhere near the goals we're trying to achieve?
Well, that goes to the wisdom of the legislation as a whole, if in fact the individual mandate is struck down, and as John said earlier, and you can, it may not be as effective in terms of reducing the number of uninsured.
Well, but the individual mandate is in one of 9 titles in the Act. There are vast stretches of the Act that have nothing at all to do with it, including the Medicaid expansion. A lot of rules about Medicare, rules about health information technology, cost control, evidence-based practice, care coordination networks, and so forth. So there's, I think the argument that the Florida District Court's decision that the entire Act had to fall because the individual mandate fell is incredibly sloppy and poorly done. he basically said, well, it'd be a lot of work to go through there and figure that out, so let's just strike the whole thing down. As a practical matter, sending the individual mandate and whatever is found not to be severable back to Congress, of course, faces the problem of trying to pass something again, which is, of course, the strategy because it's linked to the election next November. And so, both the pendency of the election and the potential for repeal of some of this, and the Supreme Court, the pending Supreme Court decision with the potential for invalidation of some of this, has actually stalled progress in a number of states, waiting to see what happens. And so all the eggs are in, just politically speaking, in the Supreme Court and in the election as to how much of this goes forward and will come to fruition.
Interesting, John, you mentioned states, and I now remember reading in the 11th Circuit decision something very interesting I didn't know or hadn't remembered. And that is at least 2 states have individual mandates in their health care plans. One is Massachusetts, the other is New Jersey. And the 11th Circuit, instead of using that in reasoning to a conclusion that, you know what, if the states can do it, doesn't that suggest that Congress has power under the Commerce Clause to do that as well? And what the 11th Circuit says, no, the opposite. What it does, this is primarily local in nature, and if Congress were to get into the act through the Supremacy Clause, it could possibly preempt the states from doing their own thing.
You have 15 minutes to think of a question. In the meantime, John, you talked about ramifications in education law, civil rights, and so on. Talk a little bit more about the ripple effect if the Medicaid provision is shot down.
Well, so one of them, I mean, 2 of them are in the cases I mentioned that were about the coercion. Remember, one of them was the federal government said to the states, if you enact an unemployment tax, we will give you a bunch of money towards your unemployment program. And the company was saying, well, that was coercion. Well, but that's an example of the kinds of strings the federal government can attach to federal funding. The whole No Child Left Behind thing, for example, is attached to the grant of federal education money, which is a quintessentially local control item. But the feds are saying, yeah, you control all that, but if you want, here's a big bunch of money. If you want it, you have to do these things. A lot of civil rights is enforced through restrictions on spending, gender, race, et cetera, in the hiring on highway projects funded with federal dollars, health, HUD project, building projects, public housing, and so on. The whole matter of public housing at all and subsidized housing is a grant of, here's some money for housing. If you want it, here's the rules. So it's all under this. And so you can see, and then on hot issues of hot social issues like the Hyde Amendment to the Medicaid, which restricts use of the fundings forbids use of the funding for abortion. If the Hyde Amendment said not only that, but you can't even use your own money or you have to have a state law that forbids abortion in order to get Medicaid funds, then I think we'd see the other side of the political spectrum saying this was a violation of the spending clause authority, right? So it opens a can of worms. Whether it should be opened or not is an interesting question. And once you get into where you draw the line, when is it that a state has no choice? Is it when they just don't want to? for the states to have their own Medicaid program with no federal funds, they would have to raise taxes. And what the plaintiffs are saying in these cases is, well, that's unthinkable. That, in effect, that's no choice for us. But it is a choice, the court said at least, right? It may be an appalling choice, but it's a choice. You can do it. You have the power to do it. So, go ahead and.
In the back, over.
Thank you, that was really interesting. Professor, I don't know if it was the Sixth Circuit or another circuit that talked about the unique nature of insurance as, in effect, constraining the possibility of Congress being able to do whatever it wants. Can you say a word about the notion that medical insurance itself, because of its pervasive nature, needs tools that answering the question about if Congress can do this, it can do anything? I thought there was some element of saying, well, we're not saying it can do anything, we're saying the insurance business, this clearly has, you could say, policy implications.
Well, I think you may be getting at the McCarran-Ferguson Act. I mean, for the longest time, according to constitutional doctrine, insurance was considered to be purely local in nature. And then the Supreme Court held, in other words, Congress didn't have power over it, and then the Supreme Court held that, in fact, the regulation of insurance, I think this was in the 30s, the regulation of insurance could indeed be regulated by Congress, and that was followed by something called the McCarran-Ferguson Act, which said that states still have primary concern with primary involvement over primary interest in regulating insurance. Congress can regulate, but Congress can only regulate insurance expressly. If it doesn't say anything about insurance, then we're not going to preempt. So what that means basically is, and the 11th Circuit talked about this, in the 11th Circuit's view, that means that insurance regulation is primarily the interest of the states, and the feds don't have that much of an interest in it at all. That's how the 11th Circuit used the McCarran-Ferguson Act. Now, I would turn that around and say that basically, given that Supreme Court decision as well, indicates that both the states and Congress can have valuable interests, important interests in regulating insurance. Now, with respect to medical insurance in particular, the 11th Circuit rejected the government's argument that medical insurance was different from not only other kinds of insurance, but also other kinds of failures to purchase different kinds of things. And the 11th Circuit said that does not give us a principled basis for decision here, going back to that line drawing point that you were mentioning earlier. Now, is that responsive to your question, or were you getting something else?
Remembering this correctly, and I thought it was the Sixth Circuit opinion, or maybe a concurrence.
Well, I haven't read them all.
Yeah, that made the opposite argument, that effectively answering the principal argument of people that want to strike it down, that this is really, if you uphold this application of Commerce Clause power, there's nothing, you have to buy vegetables, all the examples you
Right.
gave. I think it was the Sixth Circuit that said this aspect of medical insurance, the notion that everything affects everything else because of the pooling aspect that
Right.
John mentioned, that does
Yeah.
make a difference. So regardless of what other cases there are, this case is medical insurance is particularly.
Is sui generis, basically. It's unique because of the interlocking aspects of medical insurance and healthcare nationally.
The decision to effectively force people, that is economic activity that is.
And there was a question over here. Go ahead.
John, why do you think 26 states don't want to be able to expand their Medicaid coverage and have it funded 90% federally?
Can you repeat the question?
The question is, why do I think 26 states don't want a fully federally funded expansion of Medicaid for lots of their poor people? And I think the answer lies in both the sort of ideological position about the power of the federal government to instruct the states on anything, and it lies in the political realm. It was a reaction to, I think, an accomplishment of the Obama administration, and I think all of the 26, and there's a handful of governors in there too, are the opposite party. And so there was an element of that to it as well. As like the case was filed like literally the next morning. And there's been a lot of grandstanding about it. But I think underneath that is this long-running argument about the power of the federal government vis-a-vis the states.
Question in front.
I may be wrong about this, but it was my understanding that the reason that the insurance companies agreed to this whole business was because of the individual mandate. And if that's taken away, can't they say, sorry, we're out of here. That was why we did this whole thing, because we wanted this whole new pool of people to buy, who had to buy insurance. Can they do that?
If the rest of the federal law, assuming the individual mandate is struck down, is valid, then whatever requirements are imposed on the insurance industry will remain. My guess is there'll be a lot of scrambling to change regulations and the like if the individual mandate is struck down by the Supreme Court. But if the law, the rest of the law is valid, then those governed by it have to comply. It's going to be messy. There's no question about that. If that's the thrust of your question, I don't think we disagree.
And the insurance industry actually ended up opposing the act because the individual mandate wasn't strong enough. The early drafts of the bill that the insurance company supported, the insurance industry supported, had a much stiffer penalty. And they think that the one that ended up passing is too wishy-washy to compel healthy people to buy insurance. So they weren't actually for the final form of this, but the answer, I think, is if this gets struck down, they will be first in line in Congress trying to either get the rest of the insurance regulations thrown out of the act or to get an amendment going to get some kind of, figure out some strategy to get maybe a carrot strategy rather than a stick to get healthy people to participate in buying insurance.
For purposes of our discussion today, can you remember to press the on button on your microphone so that when we are recording today, so we can play it for people later, so people can hear questions?
No, my point was that the obvious thing would then be for them to attack the no pre-existing condition rule. Because that's without some kind of mandate, that's almost an inducement not to have insurance.
Well, that's why and that's why I think the administration's position on severability is that that requirement is not severable.
There was another question. No, I guess it was our advice over there. A question that was suggested to me is what are the options? What are the different things that the court could do?
I mentioned earlier that the threshold question about the individual mandate, the most visible question, involves the commerce power. But as we all know, if Congress doesn't have power under one provision, it could possibly have power under another provision. And the other provision would be the taxing power that I mentioned in passing. And the government's fallback argument with respect to the individual mandate is that this is a valid exercise of the taxing power. Problem, as the 11th Circuit pointed out, in the Act itself, when you don't comply with the individual mandate, you pay a penalty. There's a long-standing line of cases going way back to the 19th century, in which the Supreme Court began to distinguish between taxes, which are revenue-raising, and regulations, which are not governed by the taxing power. And for a long time, the Supreme Court actually enforced that distinction. Beginning in the 30s, there are the magic FDR 30s again, the Supreme Court said, you know what, that distinction doesn't really make that much difference so long as what government is doing, in addition to regulating, is raising revenue. We're going to say government can do this under the taxing power. Now you begin to see how this works over here, because pretty clearly what's going on here is an attempt to induce an incentive to comply with the individual mandate. Is that a tax or a regulation? Well, in a sense, it has aspects of both. It's designed to raise revenue, and it does raise revenue, but it's also designed to get people to buy their health insurance. What the 11th Circuit says, well, wait a minute. Here's what we're looking at. We see that this thing is called a penalty throughout the Act. It's not called a tax throughout the Act, it's called a penalty. And even though you, Congress, were shrewd enough, or maybe this just happened inadvertently, to put this into the Internal Revenue Code and make this so-called penalty payable when you file your insurance, it is basically, from everything we've seen, it is a penalty. So you're out of luck. If it's a penalty, then it regulates. If it regulates, you can't do that under the taxing power. You have to go back to the Commerce power. But we just held that you don't have power under the Commerce Clause to do it. End of discussion. In the 11th Circuit.
So among the things that could happen is, you can work it out yourself. They could uphold the individual mandate and strike down the Medicaid expansion, which at first blush seemed the bigger stretch, but maybe not. They could strike down the individual mandate and hold that it's not severable from large portions of the Affordable Care Act, sending the whole thing back to Congress. They could strike down the individual mandate and say it is severable from everything else, and, again, sending the whole thing back to Congress to see if you can figure it out. One of the things is that they could uphold the whole structure, but write the decision in a way that opens up future battles around spending clause authority and Commerce Clause authority. And that would be a sort of splitting the baby kind of thing with the ideological side of this. But it's really, that's a good question because there's a lot of permutations for how this could come out. And they could imply the Anti-Injunction Act, say this is a tax, and the case doesn't belong in court. Out of here. See you in 2015.
Do you notice, by the way, the government has a dilemma? On the one hand, it's arguing that it's a tax. On the other hand, it's arguing that the Anti-Injunction Act, the government wants this case to be decided. It's not a tax for purposes of the Anti-Injunction Act, but it's a tax for purposes of the taxing power. Cute. You can do that. We lawyers do this all the time. It's a tax for one purpose, but not a tax for another purpose. So there's a bit of some tension there.
So where would the penalty money go? Is that into the general pot, or does it go into health care, or was that not addressed?
I think it goes to
It goes in
general revenue,
Treasury. Yeah.
right?
Go ahead.
Well, I was just going to ask if either of you has a question for each other.
No.
To wrap it up.